The courtroom fell silent. In a Manhattan courthouse on a Thursday afternoon in late May 2024, 12 jurors delivered a verdict that had never been reached in the history of the United States. A former president standing in criminal court found guilty on all 34 counts. Donald Trump became the first commander-in-chief in American history to be convicted of felony crimes, and the nation watched as the legal walls that had protected him for decades began at last to crack. This is not the end of the story. This is barely the beginning. What you are about to understand will change how you see the presidency, the courts, and the systems that are supposed to hold the most powerful people in America accountable when they break the law. To understand what happened in that courtroom, we need to go back several years and trace a path that winds through hotel rooms, federal buildings, marble hallways, and ultimately to the highest court in the land. In 2016, as Trump campaigned for the presidency, a story emerged that threatened to derail his path to the White House. Adult film actress Stormy Daniels claimed she had an intimate encounter with Trump in 2006, more than a decade before he announced his candidacy. The timing was dangerous. The Access Hollywood tape had just dropped and Trump was hemorrhaging support among suburban voters. Something had to be done. Michael Cohen, Trump's personal attorney and fixer, arranged a $130,000 payment to Daniels to keep her silent. That payment, designed to suppress negative information before a presidential election, forms the core of what sent a former president to criminal court. But here is where the legal mechanics become important. The payment itself was not illegal. Hush money agreements happen all the time in American life. What made this criminal was the way it was recorded. Trump disguised the reimbursement to Cohen as legal retainer fees in corporate books. He created falsified business records, and under New York law, falsifying business records to influence an election is a felony, not a misdemeanor. The jury heard from 22 witnesses over 4 weeks of testimony. They saw invoices, ledger entries, checks, and phone records. They heard Michael Cohen describe a repayment scheme in granular detail, explaining how he sent the money, how he was reimbursed, and how Trump himself signed at least 9 of the checks that flowed through the Trump organization. Cohen was not a sympathetic witness. He had served time in federal prison for lying to Congress, and Trump's defense team spent considerable energy trying to paint him as a liar with an agenda. But the documents did not lie. The paper trail matched Cohen's testimony, and 12 ordinary citizens looked at that evidence and reached the same conclusion. Guilty on all 34 counts. If you are just joining this analysis, make sure to subscribe and hit the notification bell so you stay informed as these cases continue to develop. This story is far from over. Now here is what most news coverage missed or downplayed in the immediate aftermath of the verdict. This case was not really about hush money. It was about whether the legal system could reach a sitting or former president at all. For years, Trump had built a reputation as someone who could weather any scandal, deflect any accusation, and transform legal vulnerability into political strength. The Manhattan case tested that reputation under conditions he could not control. He could not tweet his way out of a jury deliberation. He could not appeal to a friendly judge. He sat in that courtroom day after day as the evidence mounted, and for the first time in a long career of escaping consequences, the math caught up with him. But the hush money conviction is only one thread in a much larger tapestry of legal trouble. The classified documents case represents perhaps the most technically complex and constitutionally significant of all the prosecutions Trump faced. After leaving the White House in January 2021, Trump took boxes of material with him to his resort in Palm Beach, Florida. Some of those boxes contained classified documents, including information related to national defense. The government wants those documents back. The government has rules about who can access them, where they can be stored, and how they must be handled. Trump, by all documented accounts, did not follow those rules. Federal prosecutors obtained photographs showing boxes of classified information stored in a ballroom at Mar-a-Lago, in a bathroom and shower, in an office space, in his bedroom, and in a storage room. Think about that for a moment. Nuclear secrets, intelligence reports, military operational details sitting in a bathroom next to the toothpaste. The FBI recovered more than 300 documents marked classified from the premises. But the case went beyond mere carelessness. Prosecutors say Trump showed a classified document to people who had no security clearance. In an audio recording obtained by investigators, Trump appears to be sharing details of a military attack plan with a book publisher and 2 staff members in July 2021. He acknowledges in that recording that he cannot declassify the document even as he displays it to people who should never see it. The obstruction allegations are where the case becomes truly alarming. In May 2022, a federal grand jury issued a subpoena requiring Trump to return any remaining classified documents in his possession. Trump's lawyers certified that they had conducted a thorough search and returned everything. But the FBI later obtained evidence suggesting that Trump had directed staff members to move boxes of documents to hide them from his own attorneys and from federal investigators. He certified compliance with a subpoena while knowing he had not complied. That is not a misunderstanding. That is not a clerical error. That is a choice, documented and deliberate. Trump faced 40 felony counts in the classified documents case. His valet, Walt Nauta, faced 8 counts. A property manager, Carlos de Oliveira, faced 4 counts. The charges included willful retention of national defense information, making false statements, conspiracy to obstruct justice, and scheme to conceal. This was not a political prosecution. This was a federal case built on evidence, photographs, audio recordings, and witness testimony about how sensitive national security materials were handled after a presidency ended. But then something extraordinary happened. Trump won the November 2024 presidential election. Special counsel Jack Smith, the prosecutor leading the case, announced on November 25th that he would seek to dismiss the federal charges against Trump. The court granted that dismissal on November 26th. The Justice Department under the new administration then dropped its appeal in the cases against Nauta and de Oliveira on January 29, 2025. The classified documents case, built over years of investigation in Kujang, effectively vanished not because the evidence was weak, but because the defendant became the president again. Share this analysis with someone who deserves to understand how the legal system handles power. This information matters. The immunity question represents perhaps the most consequential constitutional ruling in modern American history. In July 2024, the Supreme Court issued its opinion in Trump v. United States, and the decision reshaped the legal landscape of presidential accountability. By a 6-3 margin, the court's conservative majority ruled that former presidents have absolute immunity for their core constitutional acts and presumptive immunity for other official actions. Only acts undertaken as a private citizen fall fully outside the shield of immunity. To understand what this means, consider the January 6 case. Trump was charged with conspiring to overturn the 2020 election, a scheme that included false electors, pressure campaigns against state officials, and attempts to use the Justice Department to validate baseless claims of fraud. The Supreme Court's ruling means that many of those actions, if deemed official, may now be shielded from prosecution. The court explicitly granted absolute immunity to a president's use of the Justice Department, even for fraudulent purposes. Think about the weight of those words. The highest court in America said a president cannot be prosecuted for deploying the machinery of federal law enforcement to serve his own political ends. Justice Sonia Sotomayor, writing in dissent and joined by Justices Elena Kagan and Ketanji Brown Jackson, issued a scathing rebuke. She argued that the majority had effectively placed presidents above the law, creating a zone of immunity that would take years of lower court litigation to define and would, in the meantime, allow criminal conduct to go unpunished. She wrote that the decision renders the presidency a creature above the law, and she was right. The majority did not disagree with her reading of the consequences. They simply weighed them differently. Here is what the immunity ruling means in practical terms. If a president uses his official powers to commit a crime, he may now be constitutionally protected from prosecution. He can be impeached and removed from office, and after removal, prosecution becomes available. But impeachment requires a 2/3 Senate vote, which historically has never removed a president from office for criminal conduct. The constitutional remedy designed to hold presidents accountable is essentially unusable for the most serious crimes. And now the criminal courts have been partially closed as well. The combination leaves a gap in accountability that the founders, who wrote the Constitution in the shadow of monarchical abuse, never anticipated. Before we move forward, I want you to understand something clearly. These are not partisan observations. These are documented legal facts that constitutional scholars across the political spectrum have recognized as unprecedented. The ACLU, not an organization known for partisan alignment, called the immunity ruling a decision that places presidents above the law. Law professors who served in Republican administrations have raised similar concerns. The institutional mechanics here transcend ordinary politics. What the Supreme Court did affects every future president, Republican or Democrat, and it affects the ability of the American people to hold those presidents accountable when they abuse the power of their office. If this analysis is helping you understand the stakes, take a moment to like this video. Your engagement signals to the algorithm that this content deserves to reach more people who need to see it. That matters more than you might think. Let us now address the question that many viewers are asking. If Trump won the election and the classified documents case was dismissed, why does any of this still matter? The answer is layered, and each layer matters. First, the hush money conviction remains on Trump's record unless overturned on appeal. He was sentenced to an unconditional discharge, meaning no prison time, but the felony convictions stand. His legal team has filed appeals, and those appeals will work their way through the New York courts for months or years. Second, the civil cases related to January 6th continue. A federal judge has ruled that Trump must face trial in civil proceedings where plaintiffs allege he incited the Capitol riot. That case is not subject to presidential immunity because civil liability operates differently than criminal prosecution. Third, and perhaps most importantly, the precedent set by the Supreme Court's immunity ruling and the dismissals of federal cases establish a new baseline for what future presidents can expect when they leave office. The rules have changed, and those changes will define American constitutional law for generations. There is also the question of what happens if Trump loses a future election. The classified documents case was dismissed without prejudice, which means it could theoretically be refiled when Trump leaves office. A second Trump term ends in January 2029. At that point, if Trump loses or chooses not to run again, the federal government could theoretically resume prosecution. But that assumes a great deal about what the legal landscape looks like 4 years from now. Prosecutor rotation, judicial appointments, and political pressures make predictions unreliable. What we can say with confidence is that the legal architecture now exists to extend presidential protection well beyond what it was before the Trump era. The January 6 civil cases deserve closer examination because they illustrate how the legal system adapts when criminal paths are blocked. Members of Congress, police officers, and other individuals injured during the riot have filed civil suits alleging that Trump's rhetoric and actions contributed to the violence. A federal district court has ruled that these cases can proceed because the plaintiffs are seeking monetary damages, not criminal penalties, and because the specific acts alleged may fall outside the scope of official conduct shielded by immunity. If that ruling is upheld on appeal, Trump would face a civil trial in Washington, D.C., where juries would hear evidence about what he did and did not do on and around January 6, 2021. That trial would not send him to prison, but it would create a public record, testimony under oath, and a verdict that speaks to accountability in ways the criminal justice system currently cannot. What we are witnessing is not the end of presidential accountability, but rather its transformation. The criminal courts have shown limits. The Supreme Court has redefined the constitutional boundaries. But the civil system, the electoral system, and the system of public opinion all continue to operate. Trump won the 2024 election despite the hush money conviction, despite the classified documents evidence, and despite the January 6 Select Committee hearings. The legal system did not remove him from political contention, but it did something else. It created a record. Every document released, every testimony given, every verdict delivered adds to a body of publicly accessible information about what happened during the Trump presidency and its aftermath. Future historians, journalists, and citizens will navigate that record, and future courts confronting facts we cannot yet anticipate will interpret the precedents being set today. The constitutional questions raised by these cases will outlast the Trump era by decades. The immunity ruling addresses official acts in ways that lower courts will spend years parsing. The classified documents precedent, even though the case was dismissed, establishes what evidence the government can collect, how a president can be questioned, and what procedural protections apply to a former commander-in-chief. The hush money conviction establishes that business records falsified to influence elections can support felony charges against anyone, including presidents. These precedents do not disappear when a case ends. They become part of the legal infrastructure that governs everyone. What should you take away from all of this? First, the legal system did function, even when the outcomes were complicated. Trump sat in a criminal courtroom and was judged by a jury of his peers. He was convicted on felony charges. That has never happened before, and it matters. Second, the system also showed its limits. The classified documents case, built on overwhelming evidence, vanished not because of weakness in the evidence, but because of a change in political circumstances. The Supreme Court rewrote the rules of accountability in ways that will take years to fully understand. Third, the story is not over. Appeals continue. Civil cases proceed. The legal architecture continues to evolve, and the decisions made in the next few years will determine whether American presidents face genuine consequences when they break the law, or whether the immunity rulings and dismissals become permanent features of the constitutional landscape. The question at the center of all of this is not really about Donald Trump. It is about whether any person who holds the power of the presidency can be held accountable when they abuse that power. The founders feared exactly this problem. They built checks and balances into the Constitution precisely because they understood that concentrated power creates temptation, and that temptation, when unchecked, leads to abuse. The cases we have discussed represent the modern iteration of that ancient tension between power and accountability. The resolution will shape American governance for generations. If you have watched this far, you are someone who wants to understand what is actually happening, not just what the news cycle is saying. That is exactly the kind of viewer who makes this content worth creating. Keep watching, keep asking questions, and keep demanding that the legal system work the way it is supposed to work. Democracy depends on citizens who pay attention, and you are doing exactly that. The courtroom doors that opened in Manhattan in May 2024 did not close permanently. They opened onto a hallway that extends in many directions, and the destination has not yet been determined. What happens next will depend on courts, on voters, on historians, and on the American people deciding what kind of accountability they expect from the most powerful office in the world. The documents are in the record. The precedents are being set, and the story continues.